Yeah.
I don't know what feelings feel like.
Lefty, just so you know.
Back, no, middle back, right here. I don't think so.
It's me! My answers. I brought a notebook.
Hey,
You're fine.
how are you?
How are you?
I'm here. About to check it out. Well, I've been studying actually kind of helped it all kind of get together. No. Okay. That makes it a little easier. You're working, right? Yeah, I am. I've been taking off in the morning. Oh, you have? So I'll put it in 3, 4 in the morning, work 6 hours, and put 2, 3, 4 night. I don't look at credit for it. I'll use like 4 hours. I work yeah. And then I do 6 to midnight. There's finally, the couple of kids I go, none of them were trying to look at. So people are so.
Hi, Mrs. Costin. Congratulations. Hi.
How's it going?
Man, I barely missed it. The MBE. I passed the essay, but I barely went to the MBE. I barely missed it. Oh my God. I know. because she did like 4,000 questions, and she took off an MO the last 3 weeks.
Yeah.
But now I'm back to like going at it hardcore. Yeah, no, I mean, like, yeah, that's why this time, I'm not well, you know, Leah took Colorado 24/7. It's not like not our time. No, but next time. I'm glad there's more of us. Yeah, I
got a book.
I just hear the math lesson. I know. Like it's kind of intimidating because everyone's like that I know always been diligent. I started studying last week. Yes. I got a free exam at my mother-in-law. My mother-in-law got me an appetizer at a graduation gift. So, rather than calling, I'm doing
Where are you, sir?
And then
It don't look so good.
but contract, I've always like
One nice thing about being adult is go to phone. I recall the power. Chuck's was hot.
It could be a no, I'm doing
Yeah.
I don't like No, I go to that stuff right here. relevant week. So that's where I'm and there's going to be like one question on the duties, topics that like right. So, but I know that they're going to be at least I'm going to spend I'm only in so much.
Good morning.
I mean, we haven't done it going to be like Wednesday or like
Hey, Katie, you got, okay, they're going that way? Okay.
A couple girls back there basketball, but no time. Like how do you, like what should we do? Well, it's very evident that the outline where you had to
it's like
direct across.
It's like what would you do?
I did an outline. First I did like I would cross-examine the defendant because more evidence would be able to defendant through cross and be more knowledgeable.
Howdy.
I did for each piece of evidence. Like I did a header.
Be relevant.
No, I listed like how I would ask questions, and I just listed like I don't even know any questions. I didn't ask the last time. I didn't take transactions, and the only reason Alex and
Good morning.
Sarah and I were talking about
Welcome to hell, I'm the devil. You thought you'd graduate from law school. You just died and went to hell. You know. And there she is, she's your escort. Everybody know Krista Burton, Director of Student Success here? This is something we started doing this year, and I want to applaud all of you all for getting out of the sack and getting in here at 9:30, because here's the deal. You know, this is about a third of the people that are going to take the bar. Well, you're going to be better prepared at noon today than the rest of them. Okay, so somebody's going to pass the bar, somebody's going to fail the bar. You all are doing everything that you can do sitting here to pass the bar. As I told Joseph out in the hallway, today's the 1st of June. The 1st of August, this is all going to be over. You got a 60-day sentence. Okay? You got locked up. Okay? You're going to get about an hour of free time a day in gin pop. You know? And then you're going back to solitary confinement. You know? But at the end of 60 days, if you can do 60 days, stand on your head. At the end of 60 days, you got a ticket to ride for life. So do this 60 days like you've never done any other 60 days, because it's going to pay dividends that you'll never be able to fully count. Good. She knows I got a big mouth.
Again, thank you guys for coming out today. So I think you know how this is going to go. Professor Stevens is going to lecture for an hour, then you're going to have an hour to do multiple choice questions, and then we're going to go over those questions. So we will take a 5-minute break after Professor Stevens' lecture, bathroom break, and then the last 2 hours will be straight through. I will have pizza when you're done.
Hey!
From Toppers, so it's not the bad pizza. Does anybody have any like food allergies that I should know about?
Yeah, I got an allergy to Toppers pizza. I'll break out.
All right. I know Professor Stevens thanked you guys for coming out, and I want to thank you guys for coming out too, but I also think we need to thank Professor Stevens for taking his Saturday morning.
Hey! They're giving me $500. Where am I going to make $500? You know, I'd be staying at home doing. I'd get $500 to be here or stay home and do chores. Come on. Not even a close call. All right, ladies and gents all, shall we talk about a little evidence, evidently? Everybody got a copy of this? Anybody need one? Anybody else need one? Tell you what, there we go. Anybody else need one? There are more down here if you need them. How many of you all had evidence with me? How many with Professor Mannheimer? Okay. Anybody have Professor Stansky? There we go. Good, good, good. We're all represented here. For those of you that have had my class, I apologize. This is, something you've heard before probably, and your first reaction is, no, not again. But hopefully it will help orient you to the big picture. Because at this point in time, what you're going to want to do is take a global look at the law of evidence and how you can make it fit together. What you have here, I call it a conceptual outline, but it is kind of a matrix for thinking about problems in evidence. And the question that you have to ask every time when you have an evidence question is, why is this evidence being offered at this time? Because at this time means you have to look back at what facts you're given in the question to show you who's testified to what, and to the extent that you can, I don't know, how many of you all have problems with the written problems in algebra? A train starts out at, okay, all right. Very difficult. The only thing to do with these, I think, is literally what I do. I close my eyes and get a mental picture of that courtroom. What kind of a case is it? What's the witness testifying to? What did the witness testify to before? What are the witnesses going to testify to afterwards? And if you can get that scene in your mind, because that's all these questions are doing, is giving you a scene. Get that scene in your mind, and if you've studied this material, you're going to kind of, when you go through that question, have a pretty good idea of what you think the answer is. So I think the best tact with this is to read the question, rely on your own intuitive knowledge and good hard work, see if you have the answer in your head, and then look at the available answer. Why don't you get that? Then look at the available answers and see if your answer shows up in the available answers. If it doesn't, start eliminating the answers you know are not correct, and pare it down. And then you're going to get it down to one or two, and those one or two are going to cause you to think about one specific issue, and that's pretty much the way the question's going to be called. So you have to pay attention to what is said in the question, what facts you are given. You also have to pay attention to what facts you're not given. So don't operate on the assumption. For instance, we've got a question here this morning that talks about a negligent entrustment action. Driver loans the car to somebody who has a bad driving record, goes out and gets somebody to sue the driver for negligent entrustment. Well, immediately, I took the test. I default to a wrong answer. Because, negligent entrustment, okay, the driver, okay, yeah, you can use specific instances of conduct to prove that under 405B, da-da-da-da-da-da. Only problem is there's no fact in the question to show you that the driver had knowledge. So if the driver doesn't know that he or she's loaning the car to somebody who has a reckless, then there's no way, it's not negligent entrustment because they never knew. That was the thing that tripped me up. There were no facts. I assumed there were facts saying that there were knowledge, and there weren't any. Okay? So again, read those facts, and the other, I misfired. How did I do it? 9 times out of 10, I'm not reading all of the answer. I looked at the first 3 where, I can't do that, and then go on. So take your time. Read everything as thoroughly as you can. You got ample time, I think. These are not long questions. But use the time, put your brain in gear, and go with it from there. Number one, at what stage of the proceedings is the evidence being offered? In other words, that again, where these are sub-questions of why is it being offered at this time? Is it being offered on direct or rebuttal or on cross? Why are they trying to get it in? Are they trying to get it in to prove the truth of what was said? What does that bring to mind immediately? Hearsay. Or are they trying to get it in for some reason that really doesn't have anything to do with its truth? Non-hearsay. We don't have to deal with the hearsay rule. So, all of these, so what essentially you have on just these brief 2 pages is, you know, and this is just me, but 2 days before the bar exam, if I were you, I'd memorize that. Because when you get in there, if you can remember the questions to ask, you're a long way towards finding the right answer, knowing the questions to ask. So, now let me tell you about the second part of this handout here. It's called My Favorite Rule, KRE 801A. For those of you that took my class, this is Jet versus Commonwealth. This is the Kentucky rule that says, unlike the federal rule, that prior inconsistent statements come in as substantive evidence, period. Period. Under the federal rule, they only come in if they were given under oath or at a deposition. Kentucky takes the position that the limiting instruction is worthless. You may as well let it in for substantive evidence because the jury is going to assume that it's substantive evidence. Okay? This rule, this article by Bob Sanders, explains why it is critical in Kentucky and explains the difference between the Kentucky and the federal rule. Evidence can be asked on the essay. I think over the last 5 iterations of bar, twice they put a Kentucky evidence essay question in there. Invariably, this is the area that is most distinctive to Kentucky law, the Jet rule. And as a consequence, I put that in here for you just to kind of gird you against an essay question on impeachment and its effect of it. What do we know about hearsay? Well, let me back up. My understanding is that this exam is going to predominantly test you on hearsay, character, and impeachment. So let's spend a little time with those areas. Hearsay, golly, you got to memorize that definition. You know, and I apologize, guys, but I'm going to, memorize. And the reason memorize is because when you go into that bar examination, you're going to be under stress, right? Everybody's going to be under stress. Going to be the worst day of everybody's life up to that point. You got what you committed to memory. There's no bomb going off. There's nobody saying anything to you. There's no question that's going to be presented to you that's going to destroy what's in that between the ears memorized. That's your security blanket. That keeps you from blowing up. I've done my work. I know it's drilled in. Okay, so bring it. That's kind of the attitude you want to have. But it's just going to take gut rote memorization. That's all there is to it. To build that level of security with. At this point in time, darn good and well, the study of law isn't coming by osmosis. It's not coming by this rarefied atmosphere that we have here in the law school that you just sit and absorb it, and lo and behold, you've got the tools you need. You You're going to have to just grind it. You know, you got friends in medical school. You know, at least you're not memorizing body parts. You know, I mean, you're memorizing things that actually have some utility to, you know, a legal system. But they're memorizing too. So memorize. No easy way around it. Hearsay. Hearsay is a statement other than one uttered by the declarant while testifying at a trial or hearing, offered in evidence to prove the truth of its contents. Three hooks. Three hooks. Got to know the definition of statement. You then have to go back to that question we asked of why is this evidence being offered at this time, to make the determination about whether the evidence is being offered to prove its truth or whether the evidence is being offered for some non-truthful but yet relevant purpose, such as, can anybody rattle off the four general categories of non-hearsay? Anybody rattle them off? I knew it too. All right. State of mind of the hearer, the speaker, simply to show that a statement was made. One, two, three, four. Statements having independent legal significance. Now, what do we mean by that? Well, at this point in time, what you need to know are what are the facts that get you to this one. Invariably, this is the example of, I offer you $5,000 for your car. You know, so the issue is, why is that evidence being offered at this time? Well, if the issue was there a contract at all, what does the phrase, open quote, I offer you $5,000 for your car, satisfy? That's the offer, right? It's not being introduced at that point to prove that $5,000 was the price. It may be offered again for those purposes, but if it's offered for those purposes, now it's being offered to prove the truth of what is said, i.e. that it was $5,000, and now we've got a hearsay problem. Does everybody see that? Guys, this is the point. You know, this is not class. You understand that? This is the point where you guys go, I don't understand what the hell you're talking about. Okay? You know, nobody's going to ding you for that. That's what you're supposed to do here. Okay? So if you don't get it, speak up, because I guarantee if you don't get it, 15 others don't get it. All right? All right. So we get down into the sub-definitions under 3 of what a statement is. But this is, to some extent, this is a little bit like UCC at this point. You know how UCC doesn't make any sense if you don't memorize the definitions? Pretty much the same thing here. You got to use these memorized definitions to come up with your answer. And so really what you have there in 3 is a longer distillation of just what we went through. But for instance, to show the state of mind of the hearer, I use this old case of Illinois Railroad v. Evans, where essentially a train runs over a handcar on the track ahead of it. The estate is suing the railroad. They bring on the fireman, who plaintiff calls the fireman to testify that immediately before the accident, he told the engineer, open quote, I always think you need to break those. What is the statement? I always put it in quotes mentally, you know, just so I can identify it, break it. I told him there was a handcar on the track. Okay? Now, let's run that through the rubric. Why is that evidence being offered at this time? Is it being offered to prove that there was a handcar on the track? Hell no, we got Mr. Evans squashed out there. We know there was a handcar on the track. Okay? So for what relevance in this civil litigation brought by the estate would that statement, I told him there was a handcar on the track, make? What you think? I'm picking on you. Go ahead.
That the conductor was aware.
Warning!
Yeah.
Absolutely. He had advanced knowledge that there was a handcar on the track, so now was he negligent in doing whatever he did or didn't do? Okay? So it's not being offered to prove the truth of its contents. It's being offered to show the state of mind of the hearer, the engineer, because that state of mind would have been one that he had knowledge after that point, after he was told he had knowledge. So it's not being introduced to prove the truth of its contents. Now, let's play it this way. What if the railroad, after being sued, had filed an answer and basically said, we deny that there was any accident whatsoever. We don't know what you're talking about, plaintiff. Now, plaintiff wants to introduce this same evidence. I told him there was a handcar on the track. Now, why is that evidence being offered? To show that there was a handcar on the track, because there being a handcar on the track, because they denied that there was a handcar on the track, right? That's an issue in dispute. Was there a handcar on the track? So, when he says there's a handcar on the track, offered an evidence to prove that there's a handcar on the track, that's hearsay, okay? Now, we've got 29 exceptions to deal with it. Anybody want to pull one out of the hat that might roll?
Statement by a party opponent.
Who said it?
Statement by a party opponent.
That certainly could be it. Absolutely, an admission. But even in the absence of that, what could you say? Present sense impression, right? Maybe, depending upon his state of mind, an excited utterance. It's the difference between there's a handcar on the track and there's a handcar on the track. That's the difference, right there. That is exactly the difference. You spent 3 years and a lot of money to split hairs and get to this point this morning. Okay? But that is the difference. Okay? So that's why you have to ask that question, why is this evidence being offered at this time? And if you orient yourself, it's just like any sporting event. If you play baseball, you got to get the right stance in the box. If you play golf, you've got to get the right posture and the right setup. You get the right posture, you get the right setup, you're going to make a nice swing, and 9 times out of 10, you're going to get the right answer. Okay? Jump in with questions at any point, guys. All right? So basically what we have on 3 is this hearsay, non-hearsay rubric. Now, one of the other things that I do, simply because I love diagrams, is I beat my classes to death with this evidence funnel. Because the way I think you can conceptualize all of this, what you are given in those questions consists of facts. Okay? Now, we're going to take those facts, we're going to run them up here, and we're going to run them through this evidence funnel and see what kicks out the bottom. All right? But we've got screens in here that are going to sift out the improprieties. All right? So, the first screen that we're going to ask is the evidence relevant? Okay? Because you see, if it isn't relevant, we don't care. We don't need to ask any other questions, do we? Is it relevant? the answer is no, then it gets kicked out of the screen, pure and simple. Okay? Now, when we ask if it is relevant, there are subcategories of relevancy that we teach later in the course, but they are simply subsets of relevancy. So, for instance, the concept of authentication. Authentication, we're simply showing that a tangible object or thing is what it purports to be. This is the gun that was seized at the murder scene. This is the letter that the defendant wrote. And all it takes is, somebody with some modicum of knowledge to demonstrate that it's authentic. Bear in mind, jury doesn't have to buy that it's authentic, because all we're doing is showing that reasonable jurors could conclude that it's authentic. Don't have to conclude that it's authentic, but they could. From the standpoint of admissibility, that's all we care about. So authentication comes out here, and relevancy, to some extent, is like a gut call, because the test for relevancy is so broad. Does the evidence have any tendency, even the slightest tendency, to prove the proposition for which it's offered? So in other words, you can make the determination that, try this. There's a murder prosecution, and the prosecution wants to introduce evidence that 10 years before the defendant shot Plaintiff's dog, shot the victim's dog. Okay? Murder prosecution, 10 years before. Does that have any tendency to prove the proposition for which it's offered? No, come on, answer. Yeah. Not much. Pretty darn weak, isn't it, Danny? But any means 1%. So if it is even in the slightest degree relevant, we're going to call it relevant. All to the point of these screens, if you will, these imaginary screens in this sifter, these holes here at relevancy, they're great big holes. They're great big holes. Now, one of the other subsets under authentication, when we talk about relevancy, we're talking about 401 and 402. But also what comes into play at this point, and you look at this from the standpoint of the judge. The judge is making these evidentiary decisions, isn't she? No, that's the gut call for her at the bench. So, she may determine that it's relevant. But her next go-to is 403. At this point, because she's going to say, well, it's relevant, but is its probative value substantially outweighed by its prejudicial effect? To wit, this murder trial, we need to show that there is a dead body, right? For these purposes, the prosecution wishes to bring in the decapitated head of the victim, having been decapitated at the instance of the defendant. Relevant? Of course it's relevant. Think the judge would throw it out under 403? Right. So all to the point of, and one of the calls for the judge under 403, and one of the things that you need to factor is, are there other mechanisms by which they can demonstrate the point? Okay, in other words, no, we don't need the severed head, on a pike in the courtroom to prove there was a dead body. Death certificate would be nice, A coroner's statement would be nice. So part of the 403 calculation for the judge is what other proof do they have? You know, and so the less likelihood they have other proof, the higher the probative value of this piece of evidence goes, right? You see that? You know, there ain't any other way. The probative value goes pretty high. On the other hand, you know, the converse is also true. The more they have, the greater the likelihood that this piece, the probative value of which substantially is substantially outweighed by prejudice. Okay? So 401 and 403 go together. So in your mind, if it's relevant, I suggest the next question that you have to ask is its probative value substantially outweighed by the prejudice to the victim, or prejudice to the other side? Okay, 401, 403. Okay, we all good here? Yes, ma'am.
How often are the other elements of that audit tested, like the misleading the jury and the...
Like what? Say something.
Like confusion and misleading the jury and the other elements other than prejudice, how often are they tested?
I think quite often.
Okay.
Quite often. You know, because one of the other factors under 403 is needless consuming of time. So, for instance, you know, how many character witnesses do you need? You know, that kind of calculation.
The NCBE website has an outline that shows every MBE subject and subtopics and the percentage of the 25
cool.
questions. So for evidence, 50% of the 25 questions are relevancy. And then,
Interesting. I didn't know it was that high.
yeah.
Huh.
But it's free. You can go to the NCBE website, or you can just Google MBE frequency, and it'll
Cool.
take you to the NCBE.
Okay, thank you.
Cool. You know, all to the point of you guys have a stronger community of interest now than you ever did before. You know, you're gonna make friends in the next 60 days that maybe you didn't even know were here. So there is no set number of people who are going to fail the bar exam. So it's not like you're in competition with each other. So pull together as a community and help one another. You know, push the other person up the ladder and pull the other person below you, because you know, it's a community exercise. Okay, it's you all against the bar examiner. You know, I think for those of you in my evidence class, I think I told you on the day that I took it, I'd only been living in multi-state about 3 years by that point. The day I took it, finishing up in the afternoon, it's the last day of the exam, and somebody in the back of the room screams out, "I know one!" And at that point in time, you know, we all started to applaud. And at that point in time, this a-hole, who was the chair of the board of bar exam, "Stop that, we'll shut this down right now." And everybody went, "Ah, we've had enough of you. Get out of here." So, but in any event, it is a challenge. It is a challenge. Other questions at this point? Well, once we make it out of the sieve up here, let's operate on the assumption that we determined that it's relevant. We determined that it's not going to be excluded under 403. You see how authentication figures into relevancy there? Because if it isn't what it purports to be, and we don't have any evidence that it is what it purports to be, we cannot demonstrate its relevance, pure and simple. Okay? So now let's assume it's gone through the screen. Well, now we get down to hearsay and original documents rule, or the so-called best evidence rule. Okay? So, what do we start doing at the second level? Hearsay. Is it any statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of its contents? If you determine that it's hearsay, then what do you need to start running? Exceptions. See, the hearsay and the best evidence rule are arcane rules. then frankly shouldn't even be around. Other than the fact that, you know, give me an opportunity to earn $500 this morning, come in and tell you that. Because the reality of it is, we could have written all of this out in relevance. It's been around for so long, they just said, no, it's confused the bar. Just keep it. So, when we start asking the questions about hearsay, we ask, if it meets those criteria, it is hearsay. Then we start running those exceptions. 8031, 8032, 8033, statement of present state of mind, 8034, statement made for medical diagnosis or treatment, 8035, past recollection recorded, 8036, business records, 8037, absence of business records. So you just, and something, you know, as you run those down, the work you've done, something's going to kick out at one of those levels and ask you to ask a few more questions about it, okay? So remember, you've got, well, I think there are 27 under 803 exceptions. Statements that are exceptions to the hearsay rule, irrespective of whether the declarant is available or not. Remember that? Then under 804, you've got a list of exceptions that only apply if the declarant is unavailable. You know, I got tripped up on one of the answers here because I went for a declaration against interest, but after I reread the question, I realized the declarant wasn't unavailable. That was the wrong answer. So again, knowing what those specific requirements of those exceptions. You know, and here's the thing about it is, you know, you read that stuff in your head and you read it and it doesn't really, you know, it's just words on a page. So again, put a script together in your head of what is an excited utterance, what is a present sense impression, what is a statement statement of mental feeling or plan under 803. Try to come up with examples in your head. But no, you know, for instance, you get to past recollection recorded. First of all, you know, if you know the rule, you know the witness has to testify. The witness has to testify, and the witness has to be able to lay out a bunch of requirements that, by way of foundational questions, that she doesn't remember what's there, but it's her habit to write it, that that's her signature, that she has no reason to believe that there's anything false about it, and it was her habit to write these close in point in time after the events. After that takes place, then what does the witness do? The witness reads the document to the jury. The document doesn't go to the jury. The witness reads the document. But why? Because if we let the document go to the jury's going to have that back in the jury room, where if the witness had remembered what she was saying, all they would remember is her testimony. So we don't want to dignify this fact that she can't remember by giving the jury a document that they wouldn't otherwise have had she remembered. Okay? Now, 8036, business records. 8037, the business records are justified because there is a process that is legitimate. If that process is legitimate, then that process should also show the absence of a business record, right? In other words, if we always record these things in this way, the fact that one isn't there is indicative of the fact that it was never introduced, because had it been, the process would have picked it up. That's the idea. You get to the public records exceptions. 8038, 8039, absence of a public record. And I won't drill down on the specifics of each of those exceptions at this point in time, except to tell you that the bar materials are good on that. Just knowing the distinctions, The other ones that really that come into play that I've seen tested are 803.18, the learned treatise exception. At common law, a learned treatise could only impeach an expert witness. It could not be used as substantive evidence. In other words, the jury would be instructed, ladies and gentlemen of the jury, you may only consider the fact that Gray's attorney's textbooks of medicine differs with what Dr. Griefer says insofar as you assess the credibility of Dr. Griefer. You may not base your decision on what's reported in Gray's attorney's textbook of medicine. Make sense? Okay. So, what this changed, which, the limiting instruction is worse than worthless in my view. That said, this is kind of a recognition that the limiting instruction is worthless because the drafters of 803.18 said, you know what, if it's a learned treatise and it's recognized as a learned treatise by really anybody, including judicial notice, the jury's going to get confused that they can't use it, that they use it for one purpose but not another. Just give it to them and let them use it. So, kind of trying to tie this in your mind together, this is the same kind of thinking that led the Kentucky court to basically say that prior inconsistent statements could come in as substantive evidence, because if they can't come in as substantive evidence, they're subject to a limiting instruction, and the jury ignores the limiting instruction. So they thought, rather than this ruse, and very difficult to appeal, but to find the proof necessary for the appeal to demonstrate that they violated the limiting instruction. Okay? So, that's pretty much the distillation of hearsay. Now, best evidence are the original documents rule, Rule 1001. Basically what it says is whenever the contents of a writing are sought to be proved. Here's where this gets tricky. And these are invariably the facts that, you'll have an answer here that's going to lead you down this way. A law firm breakup, partner number one alleges that the distribution wasn't fair and it wasn't in accordance with partnership agreement. He gets on the stand and to testify and is asked, how much were the gross billings of the partnership last year? He answers $500,000. Objection. Violates the best evidence rule. Violates the original documents rule. What's the answer?
It doesn't violate because it's not offered to prove the contents of a writing.
Sing that song.
It's not offered to prove the contents of a writing.
Right. Why? He can test if he knows what the earnings of the partner. He's not being at. Now, what if the question was, what number for gross earnings did you all report on your 1040?
Wouldn't that be offered to prove the contents?
Then you're trying to prove the contents of a writing. Okay? So many things can be proved which are also memorialized in writings that don't implicate the original documents rule, because we're not trying to prove what the substance of the testimony is through a writing. And that's the only place that's going to come up. So why do we link these two? Hearsay and best evidence. Because they are arcane rules that have nothing to do with relevancy. What they do have to do with is the form, purely the form in which we want otherwise relevant evidence to come in for. Now see, you also realize that having done this, we're now beyond relevancy, right? Everything we're talking about is relevant. Because if it's irrelevant, it wouldn't have been there, or if it was too prejudicial, it wouldn't have been there. So let's operate on the assumption that we have either determined on this hearsay question that it's non-hearsay because it's not being offered to prove the truth of its contents. It's being offered for some other relevant non-hearsay purpose. Let's do that. Or we've determined that it is being offered to prove the truth of its contents, in which case we got to run our list of exceptions. Okay? One other point on relevancy. Character. You need to put character right up there with relevancy. And if you look on the second page, is it evidence of character? We've got two sets of character rules, okay? We've got a substantive set of character rules in 404 and 405, and we have a set of impeachment character rules in 607, 608, and 609. Again, why do you have to come back to that first question? Why is this evidence being offered? Because 99 times out of 100, if it is character evidence and it's being offered in the case in chief, it's going to be governed under 404 and 405. Okay? It's on direct. We're seeking to prove something substantively. On the other hand, we can have, so for instance, under 404, what do we know? First of all, that evidence of character cannot be introduced to prove action in conformity with character, except for two exceptions. We give a criminal defendant a great deal of latitude. Criminal defendant can introduce any character trait, again, that's relevant, anytime he or she wants to. We also know that for adversarial fairness under 404A2, they bring it up. Prosecution can never open this door. Never open this door. But if the defendant opens the door, the prosecution can again go through it by showing under A2 either that the defendant does have the character that the prosecution thinks he does, or that, way this comes up invariably is self-defense. You know, I didn't kill him, he tried to stab me first. You know, and he puts on evidence that he has a peaceable disposition. The prosecution can come back and show, A, he doesn't have a peaceable disposition, and 2, the victim did. Okay, so that door is open. 404A3 simply talks about the character of a witness under 608, 608, 607, 608, and 609. So it flips you over in the circumstance where you are impeaching a witness to being able to attack the witness's character for truthfulness. Any witness who takes the stand puts his or her character for truthfulness in issue. So invariably, if the witness has testified and somebody is coming at that witness on cross-examination, that's impeachment, and that is 607, 608, and 609. Okay? On the other hand, the question comes up then in 405, how do you prove character? If character is relevant under 404, how do you approve it? How do you prove it? 405A takes the position, and it tracks, frankly, with 608A. We can demonstrate character only by opinion or reputation. Opinion or reputation. 405A, 608A. And interestingly enough, 405B and 608B deal with specific instances of conduct. Specific instances of conduct to show character under 405B are not admissible except to the extent that character itself is an essential element of the charge, claim, or defense. Character itself. But just like we talked about when the writing is in play and when it's not in play, in other words, we can testify about the earnings of the partnership, but don't need the writing to prove that. By the same token, in this area, when we start talking about character, what are the circumstances under 405B where character is an essential element of the charge, claim, or defense? Let me give you an example. Danny says, Stevens stole my car. Out here in the public, y'all are talking about it out there around the booth, but, you know, I'm PO'd. I'm going to sue Danny for defamation, okay? And I offer proof that if I help little old ladies across the street and I give homeless folks money, okay? Anybody want to object? I know you'd object because you know it isn't true. But yeah.
I would object.
Yeah.
Just because you help little old ladies across the street doesn't mean that you're still not capable of stealing a car.
Not a relevant. Yeah, exactly. In other words, isn't that just a prohibition on? Well, first of all, why is it irrelevant? What do I need to defend that case? Do I need to prove?
It doesn't offer anything to negate or help your defense in proving defamation.
Correct. What do I need to prove? What do I need to prove defamation?
That Danny was false and
exactly,
and that you didn't.
And what does Danny need to sustain her defense?
That it is true.
That I stole her car. So she doesn't need to prove Stevens is a bad character to prove that, right?
Right.
All she needs. So all I'm saying is not every defamation. Don't get down the trap of when you see defamation go hot damn. Let's get specific instances in here. You know, no. Don't do that, because you got to ask yourself, what kind of defamation is it? Is it defamation of character? That example was not. You know, I could be perfectly. I could be a perfectly peaceable person and steal her car. Okay, I started to say I could be honest. So, what kinds of cases then can we use specific instances of conduct under 405B? In 40 years, I've only identified 4: negligent entrustment, negligent hiring, negligent retention, and defamation where character is defamed. Not by acts, but character. Now, Danny said, Stevens is a liar and a cheat. Okay. The fact that I found somebody's wallet and returned it to them. Okay. Relevant at that point in time? Yeah. Specific instances of conduct under 405B? Yeah. Yeah. Everybody understand what we mean by negligent entrustment, negligent, you know, so this is the issue, and you're going to have a question here. This is the issue of, okay, my son is 15 and his good buddy is 16, and I loan his good buddy my car, but, you know, I realize he's had 4 speeding tickets in the last 90 days, but he's a good kid, you know, and I know he wouldn't do that in my car, okay? They wreck, they get into somebody. I get sued, okay? Negligent entrustment, yeah, I knew or should have known of the driver's reputation before I entrusted my vehicle to him. Now, the negligent hiring, negligent retention is, you hire the guy with 3 assault charges on his record as your bouncer, okay? Good bouncer. Negligent hiring, when the bouncer, beats the living daylights out of somebody, breaks their skull open. Yeah. What if, okay, let's say, through an exercise of diligence, you didn't discover when you hired him that he had a past record of violence and convictions for it. But you find out during the course, an insurance audit. They come in and do a background check on all the employees, for purposes of your insurance, and they tell you at that point in time, hey, this guy's got 2 prior assaults. You keep him notwithstanding negligent retention. Okay? So, those are and see, all of that is about character. I should have known his character. I should have known the character of the kid that drove my car. I should have known the character because it was his character that should have put me on notice. Okay? So, yes, sir.
Can I ask a question about that?
Absolutely.
So, going back to the same situation where the business partner is on the stand and they ask, what did your gross profits look like on your 10K? And he says the estimated number, and they say objection, best evidence rule.
Right.
What is the next step after that? Do they have to introduce the actual document and authenticate it?
No, that objection would have been overruled.
Okay.
And I'm not sure that's what you're asking, though.
So if it was sustained, what would be the next step?
If it was sustained, then they would have to offer proof of what the document was. And then, and I tell you where you get into that is if you look down at 1001, I think it's subsection 4, they give you 3 or 4 excuses for not having the original. So we can introduce a Xerox copy, again, that's authenticated as true and accurate. We can introduce a handwritten copy, believe it or not. If we don't have that, and believe it or not, we can introduce oral testimony of what the document said if we get all the way down to the bottom of it. Rarely is that done anymore, but like I said, the rule is arcane and archaic, and that's the way it was. And you see why you would allow for a handwritten copy, because there was no mechanism for making an identical copy. He didn't have carbon paper. Okay? How are we doing on time here? I think we got 3 minutes. Yes, ma'am.
So, my biggest issue with evidence multiple choice is I can't figure out why the evidence is being offered.
Uh-huh.
So, I guess what's your best advice for, while reading a question, determine exactly why?
Timing.
Okay.
Timing. Go back. Who did what to whom when? Step it out. Okay. The witness testified. Now we got a witness on the stand who's impeaching that witness. Or now we got a witness on the stand who's brought on to impeach that witness, and questions are being asked to that witness. Why are those questions being asked of that witness at this time? And I think that'll get you where you need to be.
Okay.
Again, trying to get that mental picture of the scenario, picturing it in the courtroom. Okay.
Well, to be more specific, where I'm having trouble is with when the prosecutor offers the evidence for mimic purposes, motive, identity, things like that. They bring it first, and I just don't know. I guess the timing.
404B, you're talking about?
I don't know.
Okay. 404B, which we didn't talk about, basically said, it allows the admissibility of evidence of other crimes, wrongs, or acts for purposes other than character. And it says, such as proving motive, intent, opportunity, accident, so forth. Okay? So invariably when those come up, it is an offer of proof by the prosecutor. You're going to get an objection from the defense that it's character. The prosecutor is then going to come back and say, no, it's not. We're not talking about character. We're talking about other specific acts. We had the case in the evidence book, where a heroin dealer is selling heroin in pink balloons with a Nixon mask on the balloon. That's pretty specific, right? So so the guy goes, it wasn't me who sold the heroin. So on the issue of identity, the fact that he has sold heroin in the past, marked the same way as the heroin caught, is there not to prove his character, but because it satisfies an element of the prosecution's case in chief, i.e. motive. Or excuse me, identity. I don't know if that helps.
It helps a little.
Okay. Guys, here we'll go over the exam after. Is Christine here? Questions? Yes, ma'am.
I know whenever you offer evidence about the victim's tendencies or whatever, that they were violent, that the prosecutor can then can either cross that witness who's testifying to that and then put on witnesses of their own to rebut that assertion. Can you do the same when it's the defendant, like the defendant saying, I'm peaceful? Can they only rebut that on cross, or can they offer?
No, he's put his character in issue.
So then they can bring other witnesses on to rebut that too. Okay.
Mm-hmm. Once he opens that door substantively on character, then the prosecutor can come back through. Okay. Well, guys, at the end of this, I'm going to give you my cell number. So, as you're mucking through this stuff, if you get home, give me a call. Your tax dollars at work. Let's take 5 minutes, shall we? And then we'll run this little exam, and then we'll talk about it. Hey, Joseph.
Stop making those faces, guys. It's fun,
Tomorrow.
Oh, really? Where's your aura? Hey, well, let's walk. I should have got ideas, It's
Yeah, but I mean, if you're a delivery, they can ask you about it in line. What are they gonna do? Oh, yeah, sure. You gotta remember, defendant.
I was feeding this morning and I thought, I'm going to get nailed.
going on?
Hey, how are you? Sure, you say so. Why don't you tell me?
I misspoke. 33 to 35. MBE advising has this chart and it broke down into MBE outline.
Okay. See, my thing is like relevancy is one thing, but it's more of the like, cause that 403 has other elements of prejudice, and everyone defaults to prejudice, but then I get questions on like, you know, wasted time and stuff, so then I just I don't know how to weigh my time. So, that's all. But yeah, have you talked to her? Are you thinking? No, sorry. So
I
How you doing?
probably. I know that she
I love that stupid movie. Which one? All of them?
Stupid, all of them, because they're all on Netflix.
I watched The Spy Who Shagged Me recently. I forgot how much I loved it.
Krista, I took your advice on the essay. You know how I was terrified about the secure transactions? We had a secure transaction question on the MBE. And I was like, oh my god, I don't know what to do. So I did like that CRAPS mnemonic, like creation, attachment, and that's just how I answered it. And somehow I passed the essays, but it freaked me out. I was like, oh my god, this is like my worst nightmare.
You gotta get that box like that that you can send it to me and go out. Sometimes it was on at 7:30 and I'm like,
Oh, that would be awesome.
you just have to figure out the main rules. Whatever happens, if you don't know the answers, you write down the rules.
I mean, I just like I set up like creation, like one paragraph, and I was like, so blah blah blah.
And it's
Attachment
the
is blah blah blah.
That's and it's just the buzzword. It really is.
Like but evidence. Kentucky had an evidence one, and it wasn't set up. I don't know if you've seen it yet. It wasn't set up like an essay. It was
I never heard about it.
outline.
How would you introduce this evidence or something?
Yeah, like take your pick. Which witness, like the plaintiff or the defendant. Here's this evidence you need to get admitted. What question should you ask? So I chose the defendant. So for all of my questions, I set them up in a linear question format rather than non-linear. So, I mean, seriously, I don't know how I passed the essay. Like it was so. And then for the property, I had a property question, and it was asking whether a road was a public road or a county road. And I'm like, what is this? So then, like,
What constitutes a county road?
yeah, so I'm like, so for a public road, I was like, that several people use in the community. And for like the county, like they said that they pulled out like plats and deeds and nothing was owned by the county. So I used that and said, if it were owned by the county, it would be on the plat, it would be on the deed. So after the exam, that night in the hotel room, it bothered me. So I found that Kentucky case, one point it was a 2016 Kentucky Supreme Court case for Gallatin County, and it was the exact same fact. So whoever was either the justice, one of the justices, or the appellate lawyers, they were it was one of the lawyers. Kentucky had that common law question, and it was the Kingmaker. Did you notice that? So it was the opposite of the outcome of the Supreme Court case. Like it was the Supreme Court ruled because it was the baker's religious beliefs that he wasn't required to bake cake. But in that fact pattern, the cake baker didn't mind making it, but he was afraid that it would compromise the religious beliefs of his customers and his own business. So in the end, I think that if he would have based it on his own religious beliefs, it would have had a similar outcome. But I mean, like, I've pulled so much stuff out of my ass. Like, I mean, it was
The worst thing that I saw though was I'm on the Justice Association's email server, so like all the lawyers send out like a massive question to everybody. And they're like, do you know the answer to the graders of the exam? And he literally asked me something that I was like, you're supposed to be grading these exams. Like, I'm dead. It was really basic. I sent a screenshot of the email to my friend and was like, he's grading exams. But oh well, I passed that essay. I'm prepared now.
we're gonna have to meet.
We can see it.
I know, like I knew when I walked out of there that I felt it. As soon as I got up and turned everything in and I was leaving, I didn't remember any of the questions. And like Sarah and Brady Rexro, like they were all talking about these questions, and I was like, dude, I don't know what you're talking about. I'm sure it was on there, and I know I answered it. So that's how I kind of knew that I failed. It was really weird.
Sarah, like, would do practice tests every day.
Hi, Sarah.
Are you talking about Sarah Whitfield?
No.
Oh.
Harlow.
Okay, Harlow, yeah. Yeah. I talked to her too.
Stopped out for practice
I talked to her too.
Hey, but I'm doing it completely differently this time. Like, I was more worried about the administration because, like, I didn't do transactions. And I don't know, like, I'm not
Yeah.
they have these 30-day contracts, and, like, I don't know, like, my mother-in-law bought me adaptive bars.
That's what I got. I really liked it.
I'm born above a 60%. So I'm like, I'm not in the and most of the time I'm on this is all in the so I'm gonna study that initially because real property, evidence, and info.
Those are my three words.
Real property, I just went through all the lessons and stuff, and I'm like, future interest in licensing, and I'm like, I don't get it. I don't know what to do. Hey, did Leah take a photo in February? Leah took it in Colorado in February. She failed, and Kentucky is making her take it.
I know you're polite.
Kentucky's making her take. Like she's sitting for Kentucky. Oh, okay.
I know you're polite, but don't be funny.
Okay. She can't take any portion of her Colorado. So now she had to pay the whole bar exam price.
Are we short one?
Poor thing. So, Emily, I did this. This is real property on my wall at the house. Send that to me.
Everybody got one? What's the time here? An hour?
All right, guys, so coming around is your multiple choice questions. There are 34 questions. 34 questions is roughly what you should be completed in 1 hour on the bar exam, which is why we have 34 questions today. So once everyone gets an exam, you will, Does everyone have questions? Okay, before we start, I do have one question. Has anyone ordered Topper's Pizza recently? Because I believe they have closed permanently.
I ordered for Janine back in like March or something. I mean, that was 2 months ago, but.
Yeah.
Down here is closed.
The one right down here is closed, right?
Was that before or after Tillman now?
Okay, so is everyone okay with Papa John's Pizza?
Yes.
Okay. You will have 1 hour. everyone ready? You may begin.
Damn, that was quick.
Assuming everyone was already done. Yeah. Okay.
Like your life bag, someone, aside from being chained inside your house.
Okay, that's what was it?
Like there's so many like that.
Yeah, it is. Yeah, I have the neighbor.
That's the whole idea.
I'm going to be doing a lot of art.
Good idea. Hey guys, we're kind of in a quandary as to how best to help you through this next thing, because what we've handed out to you are the comprehensive answers to all that's there. I kind of think I'd rather you all spend the time drilling down on that and asking me any questions that you have about why the right answers or the wrong answers, as opposed to trying to orally walk it through knowing full well you're going to go back and read it in detail. So why, if that's all right with you, spend some time. Yes, ma'am.
How do you read this?
Very carefully.
Okay, so the format of the answer explanations is backwards. The question is actually below the answer explanation.
Thanks, sir.
And then when you look at the first page, the first one, it says correct answer and it has the number 3. So 1 equals A, 2 equals B, 3 equals C, 4 equals D.
I didn't feel secure about that at all. They would sometimes go around. That was easier to ferret out.
Right.
Oh, yeah. Yeah.
Just kidding.
Watching you guys instead of the response being I know when it's going to be I found one. Right. End of the month. Second week. I feel sorry.
Oh, there it is.
Mike.
Doing that now. There's two that I changed the answers on that it was right, and then I changed it. I hate when I do that. I'm really bad to do that. Never do that. Although you think I would have wanted by now.
Oh, you know why? Roger Phillips. Oh, yeah. 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 I'm sure you
I had fun with it. Right.
And that's basically what they want. You know? Oh, yeah. Oh, yeah. Well, you got the rip here. Come here, baby. Hey. You never know. You never know. Oh, my God. I've tried. Good golf. I mean, what's she going to do the first time, you know? How to do?
I don't know why.
I would say, frankly, leave that rule number. Because there's some little one word hint, which is that's fine. You know, but if you recite that rule in your head, you know. And my problem, there's one question. How about the rest of you? 69B question. And I said, oh no, it's not a felony, you can't come in. Then I realized the rule didn't say that. The rule said if it is a crime, the elements of which, you know, are dishonesty, that make a difference if they tripped it because they put in misdemeanor. And that was a red herring to get me off track. You know. Yeah. That's true. That's true. Yeah. Right. Well, but here's the other thing. If you go back and look at those answers, that is going to tell you whether you know the rule. You know what I'm saying? That, you know, look. Oh, well, I took this answer, but there was something. You know, something that I didn't get right? So that's kind of one reason why we thought this was probably the best exercise. Oh yeah, and that's frustrating too. What, 67? So you got a 67? Girl? Bring it. Where the hell with it? Take care of each other.
I think I know. It's pretty bad for me. I got some rough. I'm the one that went. I don't know what evidence was like. I get Eddie.
Yeah. And every. Charlie. You know, and so every oh,
We're gonna go. I know, I can't either. It's not doing me any good right now.
Yeah.
Every time. I feel like that's really good on my own. I always improve.
Alex said something about,
What's next week?
is it a contract? Yeah. Alex said something about like samples of formats for essays that like are most likely to be tested. I don't know if she told me she got it from you or someone else. Sound familiar?
Hey, not at all. Not at all.
I'm here, Ohio.
Oh, yeah. Not out
I
there
got
now.
mine from Professor Carlin.
Okay.
Krista would probably have it.
That like goes through like different formats for most likely like essay questions.
For contracts, and contracts was not on Kentucky, and it was not on the MBE, so you're gonna have a contract question. It wasn't on the February one. Like, we didn't have a Kentucky one or an MBE. Kentucky essays were like, they were like the essays.
So you don't have it?
I don't think I do.
I'm trying to remember what.
McCorley gave us more copies of it.
Okay.
You know, courtroom stuff. Just, you know.
Okay. So Alex was like telling me all kinds of stuff on Monday, and I can't remember everything.
Talking about? That's what I think.
It was like the format for like an essay, or for a memo, like a format for like a demand letter, or format for like different.
Oh. Well, I didn't take the MBE.
You also got staff.
Not for an MPT, for essays.
Yeah, but MPTs are going to translate to your essays.
We just can't make it up.
Right, 3 of them.
Yeah, I don't have formats for those. I don't think. But I just have it.
I'll ask her what she was talking about because I can't even remember exactly what she was saying. Or I could be totally making it up, but I swear she told me that.
Yeah. Sure. Yeah. Miss C, you got one? Which one?
Here, wait, which one? Wait for a guy to come in and see the paint. He kind of does it on the side. Oh, he's fine. It's an electrician. Oh.
I guess I'm confusing it with like an expert report.
Is it the right answer? Okay. Here's why D is the right answer.
I don't know.
It's not here. We know it's here. Right. Inadmissible as past recollection. Because in order to go that, You have to have the testimony.
Well,
drafted by the accountant that testifies. And that's why it's not a business record, which is why that you wind up with
talked to one guy who graduated last year.
There you see, and I did the same thing. Instead of
Like where more people they want to spend their time, I have to approve my time.
yeah.
Like I've been keeping track of having on adaptable, and I'm at my second, which is when I finish it. Well, no, but I barely did. Yeah. So here's something to try that. I mean, for a week, this next week, when you do practice, do a set your timer for set 30 seconds. Because that's how much you have. They don't there. You're going to work the math. I'm trying to remind myself.
Hey, how can we help?
I have to say, so my questions that I got right, that I
That's correct. Well, I'll tell you, we had a problem. I misread the answer. Yeah. Well,
on your safe don't freak out.
oh yeah.
I put all the things. I always look at the job. Like I have an evidence from
Like they gave you that pattern to have a conversation and like the experience and what are you developing on that and then they so there were like all of these
That was fun.
I don't know if it was exactly described to you, but like the overall concept of the other and then there was this
Oh, I'm sorry. There ain't anything else.
that night, I'm in my hotel room and I'm like,
I think that was
So I just, I finally got that one. Oh, good. Can you help?
Well, the other.
like I've done really well. Like my traction is up and I'm not mad that I spent more money than everyone else. Yeah. Yeah, so that's what I don't it's so hard. I can't wrap my head around it. I mean, and like with evidence, not terrible at evidence. Sarah Marlowe, her Barbary thing that she did, told her that she was 99% Wow, that is, but she wasn't like, she really kind of, I think well, I think that like, I'm going to talk to you about but with it, I don't know, I liked it, and I stuff wasn't exciting, but Marks has always been like, but now, like, kind of like, I'm like in the middle.
Yeah, I had trouble with it.
So I guess you and Clarissa, you and Alex will be there different days, right? Because you have to do the MBE, she has to do the SE. Leah's going to be there both days. I'll be there. Oh, if I should wait. Stay at the hotel. I am. I booked a room a while ago. Like, I want to be there and not have to worry about anything.
Well, what it
has access to this past set of essay questions. They can't give you, I don't think they can give you the MBE. I don't think they can.
their point
Like, oh, here you go. Not right away anyway. But Kentucky had a common law question, a property question.
Not a great answer.
Worse.
Oh, it is.
There was family law.
That one was like,
Yeah, that was
I wrote McFarland.
Alright. Hey, how are you, man? Good to see you.
came to see that.
Yeah, I
Arby's
appreciate
wrote
it.
me on evidence like forever.
What did
Arby's wrote that. I've already been working on it.
Oh, great. You just helped us.
Actually, your problem is really good. I wish Manheim would.
It's a
I didn't understand it.
Okay, so dealt with open and obvious doctrine. Thank you, McFarland, for that legal memo, by the way. Yeah. Duty to invitee proceed towards the department motion for summary judgment. There was a Crimpo essay on the Fourth Amendment, at least
6 hours more.
Over the whole
the
year.
evidence that they know talking about. A con law, which dealt with the 14th Amendment and the First Amendment, like freedom of speech. Yeah. Property.
Oh my God.
MBE had a secure transaction question.
I hate secure transactions.
Partnership ability, trust question. Trust has been tested and last July. But don't necessarily really getting trust. Yeah. There was a criminal law, which is really easy. Larceny, burglary, and receipt of stolen property. And then there was a civil procedure question on subject matter jurisdiction, personal jurisdiction, and property.
Charity told me the other day.
Basically everything. Just gotta know it all.
Now you have to know all the things. But you'll feel better about the MBA
Yeah.
than you will the MBE. And like the secure transaction, I didn't take that class.
I didn't either.
So
I've already done the lectures on it.
Alex did me a YouTube video after for the crap, but he whatever the R is, attachment, perfection,
priority.
What is it? Rail? Yeah. What's the R? I don't remember. Something, whatever the R is.
Yeah.
So I had no.
I know it's all about attachment and perfection.
Yeah.
And priority.
So I knew nothing about secure transactions. Like even after watching the video, so I did an IRAC, and for my analysis, like I did creation, like I recited all that. So on my analysis, I didn't see like the R, like yeah. And somehow I passed.
Yeah.
Well, I was
Doesn't matter.
I'm going for when people say take it for. That's okay.
First of all, I don't think it's great. Take care.
I don't know about what to say.
I can't concentrate in this
All right. Oh, okay.
Like from year to year. I don't know. You want me to give you a brief?
And I tell you, they're going to give you they're going to have to give you that. They're going to tell you it's not like there's some institutional knowledge about yeah.
I haven't done that yet.
I really felt vacant on that. Hey guys, I'm going to take my leave if nobody else has any questions. Thank you. As Leslie, I get everything you say. No, ma'am. Take care, Jim. Thank you, sir. Howdy.
Hello.
You got a question?
I do.
Hi, Kelsey.
So, number 27, there was like a conspiracy to.
How many questions were there total? 30. What's number 2? What's the facts?
So the small terrorist group and they conspired to bomb the military. I was in between the two. Yeah, I marked out the tweet and then I was like, because he died, so I didn't know why.
Let me see the test questions.
Every time I'm like,
This is it's number 27.
you just know what it is.
Yes.
But I guess that
She answered too.
Yeah, so it wasn't in perfect.
what kind of that?
Which did.
not furtherance.
But it was still on.
C, right?
What?
C,
Well,
B,
no, they said it was B. Yeah.
B, statement against innocence.
Yeah. But I thought it was.
Okay, all right, he's unavailable. All right.
I know, but why should it be an admission by a co-conspirator? Because he carried on with it, like the bomb, he planted the bomb and it detonated early. But it was a conspiracy.
The statements he made were not in furtherance.
There you go. There you go.
So can you give me an example of like what would be in furtherance?
Yeah, one co-conspirator saying to another one, hey, go plant that bomb over there.
Oh, okay, but he's still alive.
Right,
Okay.
right.
But I thought the rule
Right.
was.
Here's a question. I'm going to tweak that question just a little bit. What if he told the military officer or whatever, we've got bombs planted all over the place, you're going to die, and then he died? Would that be
That's much closer to furtherance.
yeah.
Much closer to furtherance. Yeah,
That's something revealing.
Okay, good.
correct.
You know, 2 versus 2.
That would be closer to it.
You see that, Taryn?
No, because I thought the rule was that it was if it was a statement made during or in furtherance of the crime, and it was still during it. Like the other 3 people hadn't been apprehended
Right,
yet.
but it's not the in furtherance of it.
It had to be both.
Yes.
Oh, I thought it was or.
No, it's and.
I wish I was.
That helps.
Yeah.
Yeah. Because that's why I was like, it's still.
Yeah.
The thing that really helps is this sentence that said he told the names and locations and they were able to stop it. That really
So it was not in, yeah, it was not in confer, it was actually in derogation
Yeah.
of conspiracy.
Yeah, he's helping.
But if he had said, like, if he had told them false information,
I think
if
you
he
get the
said
furtherance
he was,
argument.
you
Yeah.
know, if they were going to plant it, you know,
Yeah.
on the south side, but
Yeah.
like they're
Yeah.
planting it on the west side.
Yeah.
Okay.
Yeah.
Okay. That would be.
That makes sense.
That was one of the hardest questions.
Or at least like 1.5 times the fact that you might be up your eye. Because then you
I'm gonna see if I have anything else before you can leave. I'm surprised you weren't wanting to golf today.
Well,
Look at his shirt.
I know, that's why I thought of golf.
no, I wouldn't, see, I don't golf anymore. I just pay for other people to golf.
Can you
My son, my daughter-in-law, and my grandson are up at the memorial today in, Columbus.
My husband's up there.
Is that right?
Mm-hmm.
Well, I don't know about you, Kelsey, but I'm just hoping that someday I can maybe enjoy the standard of living that they do.
I know.
Wouldn't it be nice?
Yeah.
just now. It's like, I was at that like third semester, third year in my
So in
first,
this one,
like,
No, not on that.
29?
I got into it.
Okay.
the nephew that was out from out of town, from out of the country, and he was like, the neighbor was
excited about it.
experiencing
Yeah,
it.
that's an exciting.
Okay, so it's or more. So because the exciting event, the stress of excitement was her telling him that. Is that? Because like I was like, this is hearsay within hearsay, because she's telling him, and then he's telling his aunt, who is now the witness.
When was her initial statement being commissioned by?
You got double hearsay, cited utterance and cited utterance.
When hers would be admission by
Yeah.
a party opponent, right? I guess.
We all know
That's what I was thinking.
Well,
Yeah, right.
but his is excited utterance because the stress, his
Correct.
exciting event,
Correct.
No.
Correct.
Yeah, I stared at that one.
Excited Utters is my favorite. I love it. Yeah, I would do that all day.
It's kind of analogous to when we had a class where the lady gets beaten up, and she's severely mentally injured. Watching the TV 11 months later, and they're arresting somebody, and she goes, "He killed me. He killed me." The exciting event is seeing it on TV.
For now. Thank you.
Right.
Thank you.
Well, and you need to make your husband, do something nice for you.
Yeah.
Right.
I agree.
Yeah.
He hangs out with you more than he hangs out with me.
What can I say?
You're a likable person.
Oh, thank you.
Hey, folks, holler if you need anything.
Thank you.
All right. Oh,
And I had to reread the test 8 times, and then I was.
That's why I went back to my first like 3 because I was so like anxious. Like
Sometimes I need a ride.
you're good.
Thank you.
You're very welcome. Applaud yourselves seriously for doing this morning. You know,
It's helpful. I figure out what
they're 2/3 of the people that aren't here.
Yeah.
You know,
Yeah.
you got up on them.
It'll be both.
Nothing else motivates me. I do want to look around the bar example. Just do better than this many.
Listen, one of the things that will get you through the middle of the night, pick out the dumbest lawyer.
Already done it.
I've
I've already done it.
Easy.
Yeah.
Oh,
Got
listen.
it.
You know, I remember, you know, I'd gone down and moved out of my parents' house about 2 weeks before the bar. You know, so I'm trying to back this U-Haul out the driveway and keep it straight. You know, and I look up there and hear my mother's waving at me. You know, and I stop and roll into that. Honey, just remember, if Tom Hines can pass, so can you. He was the circuit judge in town. You know, but you know, to tell you the truth, it kind of, well, you know, if Tom Hines can't pass, so can you. Take care.
Thank you.